Welcome all. This is our second lecture for business law at Columbia College. My name is Cassandra Janicki and I'll be your instructor for this class. Today's lesson is really dealing with, again, building that foundational knowledge that we all need as we move forward in this class. Today we'll be talking about the Constitution a little bit more in depth than we had been talking about it previously, and we'll be talking about those really nifty things called administrative agencies. So we've already talked about what a constitution is, but the Constitution, again, sets up our relationship with our government, how we are governed, and how we govern the government. And so the Constitution establishes the legislative, executive, and judicial branches, and then our legislative branch is made up of both the Senate and the House of Representatives, so we're a bicameral. Now, there are a variety of different powers that the Constitution conveys both to the federal government and to state governments. So, historical lesson, right? One of the concerns we had at the writing of the Constitution was that the federal power might have too much power over the states, and so there was this back and forth between federal power and state police power and what those would look like moving forward. So we have certain powers that are delegated to either the federal or to the state. The Constitution delineates those powers delegated solely to the federal government, which includes enacting war and or producing currency. And then we have shared powers, which the state and federal governments both share. Doesn't necessarily have to be equally, but they do share them. So one great example of that is taxation, right? We are subject to a federal income tax every year. We are also subject to a California income tax. And so the issue can become whether or not the state and the feds are co-enforcing a power that maybe should be to one or should be to the other. So that's where we still get this byplay of federal supremacy and preemption. Now, what are the state's powers? Well, the state government powers are really encapsulated in this concept of a police power. And no, that doesn't just mean the police, although that is one way that the states utilize their police power. But the police power is purposed with creating laws that protect our general welfare, our health, our safety, and in certain circumstances, our morality. A good example of utilizing state police power is in licensing requirements. So I'm a lawyer in the state of California. I am required to pass the California State Bar exam with a certain, score that qualifies me to be a lawyer. The state puts that into place to protect you, the consumers, health, safety, and welfare, because if you're utilizing someone who purports to be a lawyer but is not licensed as a lawyer, you may find yourself in quite a pickle if they misrepresent something on your behalf or if they do a really poor job of it, and then you find yourself in a position where you wouldn't have been if you had utilized a licensed attorney. The concept of ex post facto laws is one that's easy enough to conceptualize when you think about it. The government, state, or constitution cannot make something you did in the past illegal. So let's say, for example, 50 years ago, stealing somebody's car was not a crime. Let's say and it became a crime in 1989. Okay, I stole a car in 1980. In 1980, it wasn't illegal. So the government cannot come back and say, hey, Cassandra, we're going to arrest you for stealing a car when you stole it in 1980, but it wasn't a crime at that point. So you can't go backwards to prosecute somebody. And it doesn't just go along with criminal laws, it can also apply to civil laws. So, for example, if stealing a car was also a civil crime, which it is because it's theft, or a civil law violation, then they couldn't come in and say, oh, now that is a violation of the law, and so now you can be punished and or sued for that violation of the law. Now, we talked a little bit about federal supremacy before and the concept of preemption, but federal supremacy really gets at the heart of what the Constitution was purposed with addressing head on. So when we talk about federal supremacy, the concept is that the federal government is supreme in areas where they choose to regulate or in areas where the Constitution is specifically stated that they can regulate. So when we talk about express federal regulation, environmental law, great area and a great example, that is an express area of federal regulation. Not one granted to it by the U.S. Constitution, but one that the federal government has utilized. Now, there is this question often of what if Congress, right, is silent on a particular area that a state seeks to regulate? Typically, silence will be construed as the federal government saying, hey, that's a state issue, you guys can deal with it yourself. If they choose to regulate it, then what can happen is the federal supremacy clause comes into effect, and then their law will reign supreme over the states unless or until the state's law is stricter than the federal law. Now, in our last class, I talked about how under the Trump administration, we've seen tons of federal deregulation of our environmental law. Where the feds choose to deregulate, states can step in and offer additional regulations, which is exactly what the state of California has done. The federal deregulation, however, can indicate that if a state steps in to regulate where the feds have chosen not to any longer, the federal government can come after the states and sue them for a violation of a variety of different terms and conditions within the Constitution. Specifically, and most often, that's going to look like a Commerce Clause issue, which we're going to get to in a moment. Now, when we think about the Constitution, I think I told you this already, but in other countries, they change their Constitution all the time. And so we are one of the few countries that does not. And part of that, I would offer to you, stems from the conflicting theories that we have about constitutional interpretation. When we look at the Constitution and we look at what legal scholars interpret in the Constitution, we often have these two conflicting theories. Specifically, the bedrock or strict constructionalism theory, and then the living document or the liberal constructionism theory. Strict constructionalism is the interpretation of the Constitution the way that our founding fathers intended it at the time of the writing of the Constitution. Okay? Clarence Thomas, huge proponent of strict constructionalism. In fact, most conservative Supreme Court justices are and have been, and I would hazard a guess will continue to be. Versus that with a liberal constructionism interpretation, which does tend to be liberal, so folks who are lean more to the left or to the Democrat side, and their interpretation of the Constitution is living. It changes as we change. And so, you know, whatever you believe, whatever you think about, these are the two types of theories that really guide constitutional case law and constitutional precedents. And those are also influenced, I would submit, by how hard it is to amend our Constitution, right? So Article 5 method of amending is where you have to get 2/3 of every state house to vote for the amendment. We haven't done that in many years successfully. Then there's also, because that procedural avenue is so difficult to achieve, what we as lawyers and judges have done is we have begun amending the Constitution through judicial interpretation. Perfect example, the Fourth Amendment. And so that's another way to amend the Constitution. And then we have amendment by practice, which is where people just operate under a different way until that just becomes the custom. That becomes our usage of that law. And so when we look at these conflicting theories, the real focus for strict constructionalists is going to be on that Article 5 method of amending, because they typically do not like amendment by judicial interpretation, because typically those judicial amendments tend to be more liberal because they tend to be reactive to our current situation rather than what it looked like in the 1700s. Now, one of the biggest changes that we saw in the last century had to do with the Commerce Clause and the federal government's use of the Commerce Clause. So the Commerce Clause gives the federal government the power to regulate commerce with foreign nations and among the several states, and that's the key sentence there, and with the Indian tribes. So before 1937, what we had was a very weak utilization of the Commerce Clause. The interpretation at that time was that it was a state-run situation, right? The states were handling everything that they needed to, and the federal government was really focused on fighting wars, right? Because we'd had World War I and then World War II. And so we get past we're in the Great Depression, and the federal government looks at the land and is like, wow, we need to do something, and we need to do something different. So post 1937, what we saw was a very increased utilization of the Commerce Clause. And how did they do that? Well, if any of you remember from your high school civics or government class, right, we started coming up with the alphabet agencies. So we came up with the Tennessee Valley Authority. We came up with the CCC. We came up with all of these governmental organizations whose purpose was to take care of the community, right? They were welfare organizations geared towards giving people jobs, giving poor areas like Tennessee access to clean water. And so all of those types of things were really a utilization of the Commerce Clause to enact a federal police power, right? And we know from just before now, right, that the police power was really supposed to be state-focused. So you had a lot of pushback. You had a ton of pushback on that, but ultimately the Commerce Clause and the increased use of it continued. And so you have Social Security coming out of that. You have the modern welfare system coming out of that. Conceptually, all of those welfare government organizations come from the federal government's ability to regulate commerce among the several states because they needed to stabilize our economy. Now, when we look at the Commerce Clause today, we've kind of petered out on the radical utilization of the Commerce Clause, but some interesting ways that it has been used and ways that it hasn't, right? So if you look up U.S. versus Morrison, this was a case about the Violence Against Women Act, and Congress passed VAWA, and their argument behind trying to prevent violence against women and trying to make it a federal crime and trying to increase federal funding for organizations that deal with violence against women, their argument was that, hey, we get to regulate this because violence against women impacts commerce among the several states. Women who are the victims of domestic violence, whose children are the victims of domestic violence, they can't meaningfully participate in our economy. Therefore, we have to regulate the cause of that problem so that we can regulate the commerce among the several states. The United States Supreme Court did not buy that. It was a pretty big stretch. But when you look at that situation and you compare it to Obamacare, right, and the passing of the Affordable Care Act, when that went up to the Supreme Court, Justice Roberts, in a very surprising opinion, authored that opinion and said, hey, listen, us charging you a tax for not having health insurance because you not having health insurance affects the cost of health insurance in the United States, that's a reasonable tax. And requiring all Americans to have health insurance and requiring all employers to provide health insurance or access to health insurance, all of that was a situation that would regularly impact interstate commerce. And the way that they conceptualized that was that, hey, listen, every person who doesn't have access to health care has the potential to die early, to be ill, to be a drain on the public welfare and public health care systems. And so by forcing folks through this law to take ownership of that, have health insurance, they are doing a reasonable regulation of commerce among the several states. So a little bit of a expansion in the use of the Commerce Clause. And then you look at freedom of access to the Clinic Entrances Act. This is one where Congress tried to justify precluding people from picketing outside of abortion clinics through its power to regulate interstate commerce, because women who were forced to have children that they didn't want or couldn't care for was a drain on commerce amongst the several states. Also did not work, for clarity. So states ended up passing laws like that. California has one. They can't prohibit picketing outside of those organizations and outside of those clinics, but what they can do is have those, I don't know if any of you have walked past a Planned Parenthood, but I went to school at BU, and we had a Planned Parenthood on campus, and there was a ring, a line, about which you could not pass if you were picketing. Now, what we just talked about was how the Commerce Clause can be used as both a shield and as a sword, right? So when we talk about Congress enacting legislation in order to regulate commerce, they're using the Commerce Clause as a sword, right? They're fighting a problem that they perceive that we have as a result of some impaction on commerce. However, the Commerce Clause can also be used as a shield against state laws that negatively impact interstate commerce. And so one of your assignments related to this lecture will be reading about Hunt versus Washington State Apple Advertising Commission. So I'm not going to ruin that one for you. But when we look at using the Commerce Clause as a shield, there are some really excellent cases out there that show you sometimes states focus on little stuff can be detrimental to their development and can be detrimental to commerce. So, for example, Bibb versus Navajo Freight Lines. So, a state in the Midwest passed a law that said all big rig trucks passing through its state had to be equipped with special mud flaps. And you couldn't drive through the state if you didn't have the mud flaps. And so it would force out of state, okay, folks that didn't operate out of that state, it would force those folks to stop at the border, switch out their mud flaps, and then continue through the state. And then once they got through the state, to take them back out of the truck. Here's the justification. They tried to justify it under the police power and that they were trying to take care of their citizens because failure to have these kind of mud flaps on their road was dangerous. It was dangerous to drivers. It was dangerous to other people on the road. And so they were trying to say that it was a police power action. The Supreme Court disagreed and found that by doing that, it was so disruptive to interstate commerce and it negatively impacted more so out-of-state vendors that it was an unlawful infringement on interstate commerce. Similarly, length of trucks. Again, with all of the semi-trucks. A state decided, hey, listen, you can't have more than one trailer attached to a big rig. That's pretty limiting, right? And again, their justification was traffic safety. So what would happen is that once out-of-state folks got to the state line, they had to stop, have other drivers come in, bring on the trailers, and then either pass through the state, drop them off, or go around the state. Supreme Court also held that that was too impactful on interstate commerce without a justified reason, right? So the Commerce Clause can be utilized again as a sword by the federal government to expand their ability to regulate things, or as a shield so that the feds can say, hey, listen, state, you're being unreasonable. That's not a good enough reason. Too big an impact on interstate commerce. That law is unconstitutional. Now, some other powers that the feds have. Taxing power, talked about that. The spending power, so they get to spend that tax money that they collect. Wouldn't it be funny if we gave them a taxation power and then didn't allow them to spend it? Right? So there's an unwritten limitation, because it's not written in the Constitution, that all federal spending has to be for a public purpose, if they catch it. And then taxation is apportioned. So not all of the 50 states utilize state apportionment, but it is apportioned through the feds. Now, due process. What is it? What does it effectively do? When is it implicated? What does it look like? So due process is that procedural law that we talked about earlier. The law sets forth procedures that have to be followed in order for you to take away somebody's life, liberty, or pursuit of happiness. So what it does is it protects individuals from unlawful actions against them, be they criminal or civil, and it allows that person to be treated equally under the law, under the same procedure as anybody else. It's implicated most often in criminal law cases or cases that involve constitutional questions, and it looks like adequate procedure. That's what that looks like, is so long as the person got a fair shake, due process has been followed. Now, equal protection of the law. So due process is procedural, and then I would submit to you equal protection is about equal application of substantive law on each person. So some classifications of people are protected. So you can't discriminate against people because of their age, race, sex, soon to be transgender status. The discussion section for this section talks about the recent transgender rights victory at the Supreme Court level, where they found that transgender status and or binary gender, those are encapsulated into your gender. And so because of that, you can't discriminate, or the federal government can't discriminate against folks who are transgender. Now, you can discriminate against people, for clarity. Private actors can discriminate. We've had a lot of case law come down. If any of you remember the bakery that refused a gay couple to make their wedding cake, they can do that because they are not a government actor. Again, these are constitutional limitations on our government. So there are some ways that you can, or that the federal government can, discriminate against people, and that's specifically where there's a reasonable classification based on a reasonable justification. So for example, if you are an other abled person who is confined to a wheelchair, it would be appropriate and reasonable for a fire department to say, hey, listen, you can't be a firefighter because you can't walk. So that's a reasonable classification based on not just the fact that you are disabled, but that you cannot do the job. Some other clauses that are important for us, privileges and immunities is what makes it possible for people to engage in business in other states with citizens of other states. and have it not be anarchy, okay? So when you go into another state, even if you're not a resident or citizen of that state, you get to make contracts, own property, engage in business to the same extent that that state's citizens do. And that's under the Privileges and Immunities Clause. That's also really tied to interstate commerce, because we've seen a lot of interstate commerce cases come out where states will treat people from out of state differently and without good reason or without reasonable justification. And under both the Commerce Clause and the Privileges and Immunities Clause, the Supreme Court has said, hey, listen, those are too extreme. You don't have a good enough reason to do that. It's unconstitutional. And then, of course, we love the Bill of Rights, right? That's what we all think of when we think of the Constitution. Fun fact, wasn't written into the Constitution, so it had to be attached. So we, funny enough, as a people, thanks to the United States Supreme Court, think that corporations are also people too, because they are entities that continue in perpetuum and never die until the government says they die. And so the Bill of Rights under Citizens United, which is a very lengthy opinion, I think it's over 100 pages long. You can read it if you want, it's fascinating. But basically said that the Bill of Rights provides protections for people and for businesses, because businesses are people too. So businesses enjoy freedom of speech, including the right to advertise, but those advertisements can't be false or misleading. So there's a commercial speech exception to the freedom of speech protection. And businesses have the right to participate in political activities to the same extent that a regular person does. So Citizens United gets handed down in 2010 or 2011. And so in response to that, California passed Proposition 59 in the 2016 presidential election, which invalidated Citizens United and said that businesses in the state of California do not get to act or don't get to have the same protections under the California Constitution as people do, and that they cannot participate to the same extent in political activities as regular folk. Now, administrative agencies. These are so cool. So, what are they? They are governments within each other. It's the coolest thing. So, let's talk about it. So, administrative agencies are super unique. They typically have an executive, legislative, and judicial branch. And so literally, they are purposed with coming up with regulations in a particularized area, enforcing those regulations against people who violate them, and passing judgment on those people. It is the coolest thing. Literally, a little government all to themselves. And we utilize administrative agencies because they typically have the knowledge about the thing that they're regulating way better than Joe Schmo, your congressman, right? The reality is that while our congressmen and women are typically very intelligent individuals, they don't know everything. They may tell you different, but they don't. And so I would much prefer an environmental scientist telling me how to regulate the environment rather than Joe Schmo, the congressman, right? So they are purposed with creating a system that has the most intelligent regulations for a particular area. Some examples. EPA, Environmental Protection Agency, great example. IRS, the one that nobody likes, but also I don't want to know about tax law. So thank God that they know about that. The Securities and Exchange Commission, their whole existence is purposed with passing security regulations, enforcing those regulations, and then passing judgment on people who fail to follow those regulations. And then ultimately, they are governed by Congress. I know you're all really excited about that. So Congress creates administrative agencies, determines the scope of an administrative agency's ability to regulate, and ultimately will approve their regulations after they go through the public approval process. So, as I mentioned, Super unique, right? No other place besides an actual government do we see the interaction of these three different branches in a singularized agency. So they're super unique. They must provide public access to their meetings, regulatory meetings, to their judicial meetings, required public access. So that includes open records requests, open meetings, and then public announcements of agency guidelines. So when we, was that in here? Here we go. Okay, so the agency's regulations become law. The agency cannot act outside of the scope of their authority, otherwise it's called an ultra vires act. But what we also learned, again because of the EPA, is that their authority is not limited to the technology that was in existence at the time that the agency was created. So for example, the EPA was passed, or the EPA was created, I think in the late 1960s, and we've had a multitude of Clean Air Acts pass since that agency came into being. We had one in the 70s, we had one in the 80s, then we had the Clean Water Act. We've had all of these acts that have increased regulatory requirements for people basically to pollute. And Massachusetts, I think in the 1990s, sued the EPA and said that them passing the Clean Air Act was a violation of the scope of their authority because the technology that the Clean Air Act was requiring states to impose and to utilize wasn't in existence in the 1970s. So how can you tell me that we have to use that technology when it didn't even exist when you came into existence, little EPA? So cute. Supreme Court disagreed and basically said that the authority isn't limited based on technological advancements. Because if it were, we would literally depower every administrative agency every time there was an advance in technology, which doesn't make any sense because we want them to be able to regulate. We want the smartest people in the room to tell us the smartest solutions to the problems that we have, right? Now, how, you might ask, does an administrative agency adopt a regulation? Well, it is a multi-step, multi-year, typically, process. So first, Congress identifies an area where a regulations need to exist. So, for example, creation of the Environmental Protection Agency, that happened through a Congressional Enabling Act. Then, once that agency exists, additional enabling acts can be passed by Congress to increase the scope of that agency, to specifically identify an area where Congress feels regulations are necessary. So once those enabling acts are passed, the agency begins to research the problem. So again, smartest people in the room giving us the smartest solutions to the problems that we have. They propose, they create, and then propose regulations for that problem, okay? But it doesn't stop there. They then have to put forth those regulations to the public, and they have to give the public at least 30 days to comment on their regulations. So I don't know if any of you followed this. I found it, oh, sorry, picked up my computer. I found it fascinating when the FCC decided to eliminate open access to the internet, right? And so the public comment period was open not once but twice. It received a multitude, like millions of public comments, to which the FCC did not listen. And then eliminated free access to the internet. And by free, I don't mean monetarily free, but I mean a lack of regulation of the internet. The argument on one side was like, hey, we're preventing child molesters from putting child porn on the internet. And then the other side was, yeah, but you're also going to prevent, you know, opinions that you don't agree with from going on the internet, and people from accessing the internet, and allowing all these internet search engines to prioritize their own information over the information of Joe Schmo the Ragman. Really complex issue. So once that public comment period passed, the options after public comment for an administrative agency are either to pass the regulations as they were proposed, and then promulgate them, send them out, or withdraw the rule and go back to the top of the page, right, and figure out, hey, we need some more answers to fix this solution. Now, as I mentioned, so what we just talked about is the administrative agency's legislative power, right? So then we go to their executive power, which is the enforcement power. And how neat is that? So they then get to enforce the regulations that they put into place. So they have the power to investigate whether or not a violation occurred, to determine if additional regulations are needed. That's how Congress finds out that we need another enabling act. The agency tells them. And so they get to enforce their own laws. Cool, right? And then it gets to the really cool part. We're talking about rights again. That's always the best part. So there are some constitutional limitations that apply to administrative investigations. Again, were these in the Constitution? No. This is an expansion of the 4th and 5th Amendments to apply to administrative investigations and to administrative hearing regulation violations. So administrative agencies are allowed to inspect a premise without a warrant, okay? They can require production of papers. So if you are a publicly traded corporation, the SEC gets access to everything that you have. It's awesome. And we actually, the SEC actually passed a multitude of regulations after, I mean, they do every time, after every, like, you know, bubble burst, after, you know, after they're like, oh man, what happened to the economy? I guess we screwed that up a little bit. Let's try to fix it. So, for example, after Enron in the early 2000s was found to be fraudulently shredding everything, because they had been utilizing fraudulent accounting practices. 5th and 4th Amendments do not protect you in an administrative investigation, but they can in a criminal investigation. And then an agency can also require submission of periodic reports. So again, if you're a publicly traded organization on a stock exchange, the SEC requires an annual report. So if you're a stock owner, you receive, you know, a prospectus or the annual report every year telling you about the health of the company and how things are going. Now, as I mentioned, now we're in the third piece of this, which is the judicial power of an agency. So when we talk about the agency as a specialized court, they take preliminary steps. So again, that executive branch, right, handles filing a written complaint, which the party then will answer and say, oh, I didn't do it, or they'll say, oh, I did do that, sorry. Then we have an administrative hearing. So unlike a formal court process, administrative hearings are held in front of administrative law judges. So these are folks that are specifically appointed by the agency to hear cases on its behalf. So they hear the case. There are no rules of evidence, which, allow me to assure you, are numerous in nature, but there are none in an administrative law hearing. And we get to the streamlined process where we just hear out the dispute, the administrative law judge makes a decision, and then that decision is filed with the agency and with the parties. So once it makes that decision, the agency can then enforce and punish the violator, right? So they can give it a monetary penalty. In civil cases, it's only a monetary penalty, or they can do what's called a cease and desist order, where they have to stop the behavior that's violating the law. Now, you might say to yourself, well, that's nice, but what if I don't agree with the administrative law judge's decision? What if he's corrupt? He got hired by the SEC. Why is he making decisions on behalf of the SEC? That seems wrong. Well, Joe, listen here. So, within that judicial branch of an administrative agency, there are, almost exclusively every time, multiple layers of appeal process. And so before you can say, hey, listen, you guys, this isn't right, like it needs to be, you know, I've been wronged, you made the wrong decision, I need to take it to court. Before you can take it to court, you have to do what's called exhaustion of your administrative remedies. You do not get a judicial review by a court of law until the agency's decision is final, and that includes through all levels of the appellate process within the agency itself. The only time that you can take a case that isn't through that appeals process to the court without exhausting your administrative remedies is for one of these 4 reasons, right? There's no meaningful opportunity for relief. You would suffer irreparable injury if you didn't go straight to court. An appeal to the agency would be useless, which it, by the way, never is, absent a showing of some pretty severe fraud or arbitrary and capricious natures. Or there is a substantial constitutional law question in existence as a result of your administrative law proceedings. So, unless you have one of those, you don't get to take it right to a judge, a real judge. Now, some things that you can appeal from based on an administrative agency's action, right? So let's say you get through that whole appeals process and you're like, I still was wrong, I need to take it to court. You're limited in the things that you can actually appeal. So if there was a procedural law violation, you can appeal that. Success will vary depending on whether or not your substantial rights were negatively affected as a result of the procedural error. Okay. There's a substantive law or factual issue, like the law shouldn't apply to you because you're not that type of business. You're not publicly traded, so the SEC doesn't get to regulate you. Or you're like, hey, listen, that regulation is beyond the scope of the agency. They don't get to tell me how to do that because that isn't something that they get to regulate, right? That ultra vires act that I talked about earlier. Or they didn't listen. They just made a decision based on nothing, based on no fact. Their decision was arbitrary and capricious. Okay, so you're challenging the factual findings. Or again, there's some implication on a constitutional right. So those are the 5 areas that you can really appeal an administrative agency action in front of a real judge after you get through the appellate process within the administrative agency. Okay, that's it for today. I will see you next time. Have a great day.